Everyone. Today is Wednesday, February 22nd, 2023. Today's mini seminar topic would be one of the landlord-tenant issues. The topic is, can landlord do criminal background check for the tenant qualification? Okay. And also we're going to talk about Section 8 case. How can we qualify Section 8? What we can do and what we cannot do. The third topic would be whether landlord can receive 12 months rent in advance. So rent for whole month, whether we can receive that as a landlord. That is legal or illegal, etc. Okay, so first topic would be whether we can use criminal history. In other words, criminal background checking. It is legal or illegal. On Friday, June 18th, 2001, Governor Murphy signed into the law the Fair Chance in Housing Act, we called FCHA. By the way, this documentation can be found in the back pages of NJMLS listing agreement, and this documentation is actually a memorandum to all New Jersey homeowners who would be the housing provider, we call, basically a landlord or homeowners. Okay, the U.S. Department of Housing and Urban Development, which is HUD, does not prohibit the use of criminal history-based policies. In other words, yes, landlord can check criminal background of tenant. However, there are conditions, okay? It's a very important condition that affects the landlord behavior or process. We need to be very careful. So, landlord, yes, they can use criminal background of a potential tenant. However, there is condition. Let's take a look at what is the condition then, and how can landlord use the criminal background. In New Jersey, a landlord and its agent are prohibited from requiring a potential tenant to complete any housing application that includes any inquiries regarding the tenant's criminal record, okay? So it is prohibited, but when is important? Prior to there being a conditional offer. Okay, if you read this carefully and interpret more sensibly, what it means is, in order to check the criminal background of a tenant, landlord has to offer first. Offer means, okay, you are okay, you can be my tenant. Okay, we checked your financial qualification and it's okay, except I want to check your criminal background. So that's a conditional offer we call. But in other words, a landlord cannot check the criminal background until the landlord offers this house for that tenant with that condition. Condition means, okay, you are okay except your criminal background, if there is criminal background. Okay, so the order is very important. So in order for landlord to check the criminal background, the landlord has to give the offer first, which is conditional offer. Okay, the offer is basically, yes, you are okay except your criminal background. if you don't have criminal background, then yes, you can be my tenant. That is conditional offer. But you can accept. There is accept. So there's a legal documentation. You have to very carefully. Except the drug-related criminal activities for manufacture or production of methamphetamine on the premises of federally assisted housing or lifetime registration in the state sex offender registry. So we understand that in order to landlord to check the criminal background, the landlord has to give the conditional offer first to the tenant. But if tenant is involved with the drug-related criminal activities or lifetime registration in the state sex offender registry. So these two things, if they are involved, then you don't have to give the conditional offer before check the criminal record. It's a little bit complicated. Okay, so again, this is important because I want to reiterate. The landlord, cannot check the tenant's criminal record until the landlord gives the conditional offer to that prospective tenant. However, these two cases, landlord doesn't need to do that. Landlord can ask directly. First, drug-related criminal activity and lifetime registration in a state sex offender registry. Two cases is exception. Let's move on. And that offer to rent or lease a rental dwelling unit to an applicant that is contingent on a subsequent inquiry into the application's criminal record or any other eligibility criteria that the housing provider may lawfully utilize. However, these policies, should not be blanket or arbitrary and should be tailored to serve a substantial, legitimate, and non-discriminatory interest of the housing provider. In other words, it doesn't say landlord cannot check the criminal background period. It doesn't say that. It is allowed. However, with very careful caution. In other words, there is some sequence. In order to check the criminal background, the landlord first provide conditional offer to tenant. So if financially is not qualified, if tenant is not financially qualified, then they don't have to give conditional offer. Just they can say no. And but it's not that simple. Even after a conditional offer, we need to be careful. Let's say you provide a conditional offer, the housing provider may not consider any arrests or charges that did not result in a criminal conviction, and so on and so forth. What does it mean? Even you provide a conditional offer, and then landlord can check the criminal background, but the landlord may not consider only arrest or charges. It's simply sometimes a temporary arrest or some charges before result in criminal conviction. Then it's okay. In other words, So the temporary arrest or temporary charges that did not result in a criminal conviction, expunge the conviction. This is all legal terminology, so we don't want to get into detail. The convictions erased through executive pardon and vacated and otherwise legally nullified the convictions, juvenile adjudication of delinquency, and the sealed record. All these kind of things is not convicted, and sometimes they delete the record, but temporary charged and temporary arrest. Those kind of things landlord cannot consider. Okay, that means it's okay. In other words, a landlord cannot say no, okay, for the temporary arrest or just temporary charges, which did not result in a criminal conviction. And also there is exception. If a housing provider chooses to consider the applicant's criminal history after conditional offer, they may only consider. So these things, temporary arrest or kind of a pending charges, landlord cannot consider to say no, okay? But they only consider, in other words, if the tenant has the following convictions, then the landlord can say no, okay? They may only consider followings: conviction for murder, aggravated sexual assault, kidnapping, arson, human trafficking, sexual assault, endangers the welfare of a child. These kind of things, definitely landlord can say no. And also landlord can say no to convictions for any criminal crime that requires lifetime state sex offender registration. Again, we're kind of repeating. And the first degree indictable offense, like a first degree murder, I guess, released from prison for that offense within the past 6 years. So they convicted and they released from prison within the past 6 years. Okay, then they can say no, I cannot accept you as a tenant. Or a second or third degree offense, released from prison for that offense within the last 4 years. And then the fourth degree, a little bit lighter the offense, again, that offense, or released from prison for that offense within the past 1 year. Okay, so these kind of things may consider as a reason to say no. So it's a bit complicated, but it works for both. Okay, the tenant point of view is not fair to just heard no from landlord if they have just a minor arrest or minor charges. Okay. So that's the kind of a law. Again, you can find this detailed prints in the back of NJMLS listing agreement, for instance, in the back pages. They elaborated into very lengthy documentation this time. Okay. So I hope you understand what the law is trying to say to you. Okay, the another topic, since we are talking about landlord and tenant relationship, another topic would be unlawful income on NJ-led. This time, they kind of expand the content of the documentation about the lawful income. Okay, so what would be the lawful income in New Jersey right now? Of course, the major source of the lawful income, one of the main item would be Section 8, housing choice voucher. That's kind of representative lawful income. But not only the Section 8, after COVID-19, there are a lot of assistance programs. For instance, COVID-19 emergency rental assistance program, we don't hear much, CVERAP. and also State Rental Assistance Program, SRAP, and Temporary Rental Assistance, TRA, and also Eviction Prevention Program, EPP, and unemployment benefits, child support, alimony, and supplementary security income, etc. It's all considered as lawful income. Now, the question is then, with this lawful income, okay, let's say Section 8 choice voucher, how can we qualify financially? It's kind of confusing. So it says the housing provider, the landlord, must calculate any minimum income requirement, financial standard or income standard based only on the portion of the rent to be paid by the tenant rather than the entire rental amount. In other words, if Section 8 housing choice voucher covers 80% of the rent, okay? That means, let's say $1,000 rent, okay, one bedroom. The rent, the fair market rent is $1,000. And Section 8 housing voucher covers $800 per month. So automatically, usually they deposit this money directly into landlord bank account. Very nice. We don't have to do anything. The government housing authority pays directly this $800 to the landlord bank account. Good. And then tenant pays $200 every month to the landlord separately. So landlord's point of view, okay, when they calculate their own standard, okay, usually they have some standards, they can consider only, they can calculate, okay, only this $200, okay, whether they can cover, okay, this $200 with their income. Okay, that makes sense? So 80%, which is $800 coming from government authorities, so the landlord has to, they don't have to worry about, and tenant has to pay $200 per month. So if this tenant can pay $200 per month, financial qualification is acceptable. Typically, what we have, New Jersey, typically maybe the rent can be less than 30% of the income. In other words, the gross income is 3 times of monthly income payment. Usually, a landlord could accept. Okay, there is no legal guideline whatsoever, but there's a typical guideline that a landlord can use, and then typically the agent can advise. Okay. All right, so that's unlawful income situation. And the next topic would be whether the landlord can accept 12-month rent payment in advance, all in once, upfront. Is often in a lot of debates. Yes, no, and typically tenant asks that option because tenant doesn't have a good credit score, for instance, okay? But still law prohibited because the court decision for a case, the landlord cannot collect the 12-month rent in advance. The court decision is based on the law that the security deposit from tenant in New Jersey cannot exceed 1.5 month rent. That's the law, okay? The court allows the total of 2.5 months rent at the inception of the lease. In other words, 1.5 month security deposit plus first month rent. So at the inception of lease, the beginning of the lease, okay, in order to have a contract, the tenant will bring the 1.5 month of security deposit and 1 month first rent. Okay, first month rent. That's it. Okay, if landlord receives more than that, over than this amount, it can be considered additional legal deposit, which is illegal. That is why based on this fact, okay, any deposit cannot be over 1.5 month rent. So that's illegal. That's what is the court interpreting. So therefore, a landlord may not receive the 12-month rent in advance. Okay, if I add the Korean summary, 벌써 21년이 됐네요. 2021년 June 18에 Governor Murphy에서 사인을 했어요. 법 하나를 뭐냐면 FCHA, Fair Chance in Housing Act라는 법을 사인을 했는데 결국은 허드에서 집주인들한테 테넌트의 크리미널 백그라운드 체킹을 못하게 하는 건 아니에요. Okay, does not prohibit. Okay, allow 하는데 조건이 굉장히 까다로워요. 굉장히 까다롭게 됐어요. 무슨 얘기냐면은 크리미널 백그라운드를 체크하려면 okay, 그 사람한테 컨디셔널 오퍼를 주고 나서야 그 사람의 크리미널 백그라운드를 체크할 수 있다 이런 얘기예요. 뭐 실질적으로는 굉장히 어렵겠죠. 그렇게 어렵기 때문에 또 그러니까 컨디셔널 오퍼라는 건 뭐냐면 오케이, 당신이 테넌트로서 파이낸셜리 다 좋다. 단 나는 당신의 크리미널 백그라운드만 체크해서 그것만 오케이면 아무것도 없으면 나는 당신을 테넌트로 받아들이겠다 하는 게 컨디셔널 오퍼란 말이죠. 그러니까 그걸 주기 전에는 그 사람의 크리미널 백그라운드를 터치하지 마라 이런 거죠. 그런데 두 가지는 예외다. 두 가지는 뭐가 예외냐면 drug related criminal activity, 그 다음에 lifetime registration in a state sex offender registry. 그 두 개가 돼 있으면은 그거는 이렇게 무슨 컨디셔널 오퍼나 이런 거를 걸칠 필요도 없다. 그렇다면은 우리가 변호사님들한테 좀 확인을 해볼 필요가 있는데 그러면 그거는 미리 물어볼 수 있지 않느냐 그런 퀘스천이 생기죠. 그럼 테넌트한테 이 두 가지 drug-related criminal activity for the manufacture or production of methamphetamine on the premises of federally assisted housing. 뭐 좀 복잡해요 조건이. 정부 보조로 된 그런 하우징에서 메람페라민이라는 거는 쉽게 얘기하면은 한국에 옛날에 있었던 뽕이라고 그러죠. 히로뽕 뭐 그런 거 그거를 생각하시면 돼요. 아직 만들기가 간단해요. 구글에 이런 데 다 나와 있어요. 어떻게 만드는지가. 그런 거를 만든 크리미널 백그라운드가 있으면은 안 되고 그다음에 섹스 오펜더 스테이트에 등록이 돼 있어도 안 된다. 그러니까 그거는 컨디셔널 오퍼를 주고 물어볼 필요가 없다 이런 얘기겠죠. 그죠? 오케이. 그런데 또 랜로드가 고려하면 안 되는 조항들이 있어요. 그러니까 당신이 크리미널 백그라운드에 있기 때문에 안 된다 하지 못하는 것들이 있어요. temporary arrest라든지 그다음에 pending charge라든지 이런 거는 기록이 떠도 또 그거 가지고서 노를 못한다 이런 얘기죠. 그래서 이런 only arrest, temporary arrest나 pending charge인데 결국은 conviction이 안 된 거. 안 된 거예요. 결국은. 그런 거 가지고는 노할 수 없다 이런 얘기죠. 오케이? 그리고 어떤 거로만 가지고 노할 수 있느냐. 그러니까 they may only consider 어떤 거 가지고만 노할 수 있냐면 컨빅션이 확실한 거. 그러니까 살인이라든지 aggravated sexual assault라든지 kidnapping이라든지 좀 우리가 생각할 때 이건 중범이지 하는 거에 대한 컨빅션이 있을 때 노할 수 있다. 그런 얘기고요. 그 다음에 같은 종류예요. Life State Sex Offender Registration이 되어 있는 경우에도 할 수 있고, 그다음에 First Degree Indictable Offense, 뭐 First Degree Murder 뭐 이런 얘기 많이 듣죠. 아주 심한 거예요. 그리고 그걸로 인해서 과거 6년 동안을 봐서 프리즌에서 릴리즈했다. 그러면 노할 수 있다. 이제 Second Degree, Third Degree는 그런 offense가 있거나 아니면 그거로 4년 안에 감옥에서 나왔다. 그것도 노할 수 있다. Fourth Degree는 그 offense를 받았거나 아니면 1년 안에 그런 거로 해서 감옥에서 나온 사람의 경우는 노할 수 있다. 그러니까 노할 수 없는 거를 또 명시해 놨고 분명히 클리어하게 아주 컨빅션이 확실하다, 좀 중범이다 하는 거는 노할 수 있다. 이렇게 되어 있다고 보면 되겠죠. 실질적으로 이게 쾌하게 우리가 붙잡혔다. 굉장히 파이낸셜이 아주 좋다. 그래서 이 사람을 컨디셔널 오퍼를 주고 억셉트 했는데 이 사람이 크리미널 레코드가 떴다. 그러면은 조금 심각해지겠죠, 그죠? 그러면은 그 내용을 가지고 역시 변호사님한테 컨설트하는 게 좋겠다, 답이 되겠다 이런 얘기죠. 물론 그 홈 오너들한테 보내는 서한서, 주정부 주지사가 그 서한서가 리스팅 어그리먼트 뒤에 있긴 해요. 자세히 여러분들이 볼 수는 있어요. 그러나 그거에 대한 해석은 역시 우리가 할 게 아니라 변호사한테 의뢰하는 게 좋겠다. 그다음에 간단히 요거만 얘기하고 넘어가죠. lawful income도 discrimination 하지 못해요. NJ-LAD라는 거는 Law Against Discrimination. NJ는 LAD라고 부르죠. 뉴저지는. 그에 포함되는 것이 이제 코비드 이후에 많이 생겼어요. 전에는 뭐 Section 8 Housing Choice Voucher가 주로였는데 이제는 많이 생겨서 이러한 등등의 프로그램들이 있다. 이것도 다 노하지 못한다. 우리가 잘 모른다 그래가지고서 난 그걸 모르겠으니까 랜러들이 노하면 실질적으로 법에는 걸린다. 그러면 이 사람들이 오면 도대체 어떻게 우리가 이 사람들을 퀄리피케이션을 하느냐, 캘큘레이션을 어떻게 하느냐, 인컴을. 지금 그 법에는 어떻게 써 있냐 하면 주정부 주지사가 보낸 그 서한서에는 어떻게 되어 있냐 하면 정부에서 하우징 어토리티에서 도와주는 섹션 8 같은 경우에 아니면 어시스턴트 프로그램이 도와주는 포션이 있죠. 아까 말씀드렸죠. 80%라 그러면 예를 들어서 렌트 전체가 한 달에 1,000불이죠. 그러면 800불, 나머지 테넌트가 직접 내는 200불이죠. 그죠? 200불은 테넌트가 직접 내야 돼요. 랜로드한테. 그 200불에 대해서만 퀄리파이 하면 된다 이거죠. 그러니까 결국은 그 사람의 인컴이 200불에 뭐 3배 아니면은 200불에 4배가 되느냐만 계산을 하게끔 돼 있어요. Housing provider must calculate. 오케이. 그렇게만 계산하게끔 돼 있다. 그것도 일단 여러분들이 알고 계셔야 그래야 문제가 되는 것을 피할 수가 있겠다. 그 다음에 또 한 가지, 시간이 조금 지났지만 이것도 우리가 클리어하고 지나가는 게 좋을 것 같아요. 많은 경우에 12달치 렌트를 한꺼번에 받을 수 있느냐. 테넌트가 좀 약해요. 스코어도 약하고 인컴도 베리파이 할 수 있는 게 작아. 뭐 캐시는 많이 번다고 하는 경우도 있지만 그럴 경우에 그러면 테넌트가 12달치를 한꺼번에 내기 원한다. 근데 랜로드 입장에서는 받을 수가 없게 돼 있어요. 코트 디시전을 한 적이 있어요. 그 코트에서는 어떤 사실을 어떠한 법을 근거로 했느냐 하면 뉴저지 법에 시큐리티 디파짓을 1.5month 이상 받을 수 없다고 돼 있어요. 그러니까 처음에 렌트 시작할 때 1.5month 시큐리티, 그다음에 first month 렌트만 받을 수 있어요. 한꺼번에 업프런트로. 그죠? 맥시멈의 1.5month 시큐리티 디파짓은. 그러니까 그거보다 더 받는 것은 어떠한 이유로건 간에 더 받는 거는 법에 저촉이 된다라고 해석을 하는 거예요. 오케이? 그러니까 그것은 법에 걸린다. 따라서 12month를 더 받건 3개월치를 더 받건 안 된다 이거야. inception of lease, 리즈를 시작할 때에. 물론 중간에도 마찬가지겠죠. 왜냐하면 렌트비보다 더 받는 거는 디파짓으로 해당이 되기 때문에. 미리 받는 것도 디파짓에 해당이 되기 때문에 그런 해석을 코트에서는 했다. 그러니까 앞으로도 마찬가지가 되는 거죠. Okay, so I hope these three issues we dealt in this seminar, and I hope that this will help you either tenant side and the landlord side. And I hope again more landlord could join our seminar. So I hope more landlord can see our YouTube channel again. Okay, thank you for joining and see you all next week.